Okay, good morning, everyone. Today's May 24th. The time is 10 a.m. This is Judge Lopez. I'm going to call the case number 2390324, MLCJR LLC, on a continued cash collateral hearing, and I suspect we will talk a little bit about what happened in New Orleans and Judge Grable's decision and where we go next. So, about 85 folks on the line. All right. I would just ask those who represent the debtor who will be speaking today, if you can hit 5-star, and I will unmute your line. I'd like to make an appearance. I would also encourage parties to go to my page on the Southern District of Texas website. You'll find a link where to make electronic appearances in complex cases, and you will find a link for this case. Please make your electronic appearance there. Let's see. Anyone for the debtors, please hit 5-star. Okay, I've got a couple. I'm going to unmute a few lines here. Just give me a second. Just a second. Okay. Who from the debtors wish to make an appearance?
Good morning, Your Honor. It's Keith Simon from Latham for the company.
Okay. Good morning, Mr. Simon. Let's see. Go ahead.
Oh, so you had asked about New Orleans and the judge's ruling. We did post it, obviously, to our docket, at docket number 201. Judge Grable was obviously clear that the involuntary 7 in that case should be transferred to this court. So that's good. So, in terms of next steps, we're obviously proceeding forward in front of Your Honor. Obviously, now we have 2 cases pending against the same debtor in front of Your Honor. So we're going to, I assume very soon, file a motion under Rule 1015A to consolidate those 2 cases. So you don't see that every day. But I think from a procedural standpoint, it's full steam ahead in front of Your Honor.
Okay. Thank you. Let me go ahead and open it up and take other appearances at this time. There's another 713 number. I'm going to open it up. Okay.
Your Honor, that's probably my line, Ryan Monroe. Good morning.
Oh, good morning. Okay, I just unmuted another line. Let's see. Ms. Norfleet, are you there? Why don't you hit 5-star on me?
Good morning, Your Honor. Can you hear me?
Just fine.
Thank you, Your Honor. Kelly Norfleet on behalf of BP Energy Company, one of the debt lenders in the case.
Sounds great. Mr. Phillips, do you wish you hit 5-star? Maybe I can unmute your line as well. And again, if I've unmuted your line, please keep your phone on mute throughout the entire time. There you are. Okay.
Good morning, Your Honor. Lewis, on behalf of Amarillo National Bank, along with Aaron Arnold and Roger Cox from the Underwood firm.
Okay. Good morning. Good morning. Let's see. Anyone else wish to make an appearance for purposes of today, which is a continued cash collateral hearing, but I suspect we'll discuss other matters as well.
Your Honor, this is Betsy Marks from Latham & Watkins on behalf of the debtor.
Good morning, Ms. Marks.
Good morning.
Anyone else, please hit 5-star, and I'll recognize you. And if not, please keep your phone on mute. All right. I'll keep monitoring this. If anyone else wishes to make an appearance, hit 5-star. If not, I'll take appearances in the courtroom. Mr. Ruff, good morning.
Yes, good morning, Your Honor. Jason Ruff for the U.S. Trustee's Office.
Okay. All righty. Just going up and down a few more times, making sure no one else wishes to speak at this time. And for some reason, if I have missed anyone, or if anyone wishes to make a comment at any point and I don't see you, Mr. Peck, I knew it. That's what I was going to ask for, the traditional wave, but I don't see your, can you first now?
Your Honor, Stuart, can you hear me?
I can hear you just fine, Mr. Peck.
Yes, Stuart Peck, I'm on behalf of a number of trade creditors, Offshore Lifeboats, RI Marine, Keystone, All the Energy Sparrows, Flower Rentals, Bringer Catering, Swivel Rental, there's a number of them. So,
okay.
A large group of trade creditors. Yeah.
Thank you. Thank you. Good morning, sir. Okay. Let me just say at the outset, I know this has been a kind of a period where, certainly hearings in New Orleans, hearings in Houston, and another evidentiary hearing in New Orleans. I want to just go on the record and thank Judge Grable. Clearly, she took a lot of time and held an evidentiary hearing. It's clear that wrote a very thoughtful decision, and I think she and I are both big proponents of due process, transparency, and process, and I think that's exactly what everyone saw. I think the petitioning creditors had a right to a hearing in front of Judge Grable, and they had their hearing, and Judge Grable ruled, and so we find ourselves back here. So again, and clearly, I think everyone can tell she spent an incredible amount of time under a very short time period to write a very thoughtful decision, which anyone who knows her knows that's exactly what she was going to do. So again, just appreciate the coordination between the courts. I think she was, and what I'm thanking her for is really obviously not how she ruled. She was going to rule how she was going to rule, but just in terms of allowing this proceeding to proceed today, hearing here. We know we were going to have another status conference, another hearing on the continued use of cash collateral. I just thought it made a lot of sense to have a ruling from Judge Grable so that we were able to have a productive hearing today. So again, everyone entitled to process and transparency in process, and I think that's what was displayed by both courts. So Mr. Simon, let me turn things back over to you. Sounds like you're going to file something to proceed and consolidate essentially the case from New Orleans to be transferred here and converted, I suspect, into the main Chapter 11 case that was already filed here. Once
yes, sir.
Okay.
Yes, sir. If it's okay with Your Honor, can I proceed to the one item on the agenda for today?
Yeah, let me just, before you do, I just wanted to see if there was anyone in the form of just a statement that wished to make any statement, any very brief statement about kind of where everybody thinks we are.
Your Honor, Lewis and Phillips on behalf of Amarillo National Bank, we would echo Your Honor's comments about the process that the parties were provided both in this court and in the East District of Louisiana. We had very fulsome discussions and a very fulsome hearing, evidentiary. Judge Grable stayed up the night after the hearing ended probably around 6 o'clock in the evening and issued her opinion before 9 o'clock in the morning, or right around 9 o'clock in the morning, which, as Your Honor can tell by and the parties can tell by reading it, was very well thought out and very deeply thought out. And I know from Amarillo National Bank's perspective, we can't thank the court in the Eastern District enough for the process that was provided, the timely action, the patience that was provided during the hearing. Everybody got the breaks they needed. Everybody got the time they needed. And the only one that was stressed was the court. And the court handled the stress, and we appreciate her actions, attention that she gave to her ultimate ruling, and I just wanted to have A and B's position on the record in support of Your Honor's comment. Thank you.
Thank you. Anyone else wish to? All righty, Mr. Simon, you may proceed.
Thank you, Your Honor. Okay, I did unmute her. Okay, great. Okay, so, Your Honor, the one item today is our second interim DIP hearing. If Your Honor recalls, on May 16th, we received, I guess, the initial interim approval for $20 million in DIP loan financing, and we had requested at that hearing $50 million, but Your Honor, we kind of staggered the hearings. So today is the second hearing for the incremental 30. It's still the original $50 million, so there's really nothing new in terms of the request. It was simply staged into two different hearings. We did file a revised interim order. It just hit this morning at docket number 211. When Ms. Norfleet sent me the red line yesterday, I was expecting like 2 pages because it's the same order, except when you change the order to the orders, it's every single page. So that was a pleasant surprise last night when I'm like, I'll just print this out, and my printer kept going. So, but there's no substantive changes there. It's just defined terms. There was one additional reservations of rights, I believe from Argonaut, a surety bond provider. I believe that language, I know the language is in there. I believe it's resolved their reservation of rights. In terms of evidence, Your Honor, you can see we have Mr. Omohandro and Mr. Latifa in the virtual courtroom. They had submitted declarations at the initial hearing. Mr. Omohandro's was docket 34. Mr. Latif's was docket number 19. In terms of the need for the incremental 30, Your Honor, the budget that was attached to the original interim order is Exhibit B, docket number 116. That would be our evidence for why we need the second interim order. Again, they're here to testify. I would ask that those be admitted into evidence, and of course, if people want to cross-examine, they of course are both here in the courtroom.
Okay, so I will note, just for purposes of today's hearing, this is really a continuation of the first hearing, so the declarations that were admitted for purposes of that motion remain admitted for purposes of today, because really kind of the second draw, and the reason I'm just stating this for the record, I know Mr. Simon's going to agree with me, Mr. Phillips will agree as well, it's just to ensure that no one ran afoul or felt uncomfortable running afoul what Judge Grable's order had entered, and so I just wanted to make sure that we had this hearing today to continue, but essentially all the evidence for the entire amount was put into evidence at the first day hearing. So really the question that I have for the parties is, I guess starting off, does anyone wish to speak or have any questions about the incremental amount?
Your Honor, Lewis and Phillips, on behalf of Amarillo National Bank, we would point out that not only were the declarations introduced, and we agree that they should be evidence for this hearing, but also Mr. Alejandro was made subject to cross-examination and was in fact examined, and we would assume that that examination and that testimony would be testimony applicable to today as well. And we're fully in support. We second Mr. Simon's observation that the only changes to the form of order were to make it fit with the two hearings, the second interim hearing being added to the first interim hearing, and the one Argonaut reservation, which didn't substantively affect anybody's rights, just made clear that there was no effect to the substantive rights of Argonaut, just like the Chevron reservation in the original version of the first version of the interim order. So we would submit that perhaps there's additional evidence, but the evidence is already in. Thank you.
Thank you. Does anyone wish to be heard in connection with this motion?
Your Honor, Kelly Northlead on behalf of BP Energy Company. One other point that I would just point out to Your Honor, as Mr. Simon noted, I took the pen on revising this from the first interim order to the second interim order. There was some language requested, some clarifying language requested by counsel for Archrock, and that is at it's new paragraph 39 of the interim order. There was existing language regarding permitted prior liens that was in there. They asked for some additional clarifications. We made those changes, and I believe that resolves their concerns. So just wanted to point that out for Your Honor's reference.
Okay, thank you. Anyone else wish to be heard? Okay.
Oh, we have a hand wave.
Yes. Mr. Peck, I think you're unmuted.
Yes, Stuart Peck. I will say that we had a fulsome hearing on Monday. We put forth our effort and all, and we understand the ruling. We also understand the need for this debtor to have debt financing. We're not against that. I had a right to cross-examine last time because we just didn't have some details on it. So there's $180 million of some trade goes to Louisiana, and it's having a devastating effect. So it's in everybody's best interest to do the best we can to allow this debt money to come in. So that's our position.
Thank you.
We reserve all rights too, Judge, for the final verdict, obviously.
Absolutely. Anyone else wish to be heard? Let me ask all the parties if I know I was going to go through the final or the red line and just make sure that I read everything and read all the changes carefully. Has everyone had an opportunity to read the revised order?
A and B hands, Your Honor.
Okay. So what I will do is, just for the sake of clarity, I'm going to share my screen. I'm going to put the red line up, and I'm just going to go page by page and just, I know a lot of it looks like it's just changing the to the second or something like that, but just so we can all look at it together and one time, and then I'll get it signed. One thing I do know, and while I'm looking at this, we can start thinking about this, is I think there's probably somewhere in here I need to plug in a final hearing date, and I need to know what date you're thinking about.
Your Honor, didn't we pick the 7th of June last time?
Yeah, I knew we did. I was just hoping someone remembered what it was, because I didn't.
I think it was the 7th of June, and I remember it because I'm leaving the country on the 8th of June.
Yeah.
So I was very happy about that.
Hoping someone can just, or maybe my clerk can just pull up the first order and see exactly what I said and just send me an email so I can. I'm going to read the second. All right, let me share my screen. Mr. Phillips, I'm in the process trying to train my law clerk that when she hears me ask questions, that it's coded for, that means you know. They're ready for law firm life.
Understood.
Okay.
And Your Honor, do you want me to do like my version of page narration?
No. I'm just pulling it up. I'm reading it here, but I want to read it just kind of live. And if I have any questions, I'll stop anyone. But I know that most of it is just confirming changes.
Okay.
Oh, good catch. Just making sure the paragraphs lined up. 12C was 12C. Got it. Okay. This looks good to me.
Great. Thank you, Your Honor. I think last time we had said June 7th for the final dip hearing, and I thought I heard an objection deadline of June 2nd, if that's my memory.
That sounds right. Pulling up the current interim order now. Let's see. On my last interim, that's right. It's when we schedule the final hearings, right? For like, I need to find an interim order. Cash management will have it. Yep. I've got June 7th at 10 a.m. and then June 2 at 5 p.m. That's our scheduled dates. I will plug them into this order and get them. I'll get on the docket shortly.
Excellent.
Alrighty. Anything else we need to cover today?
No, Your Honor. Thank you for your time, and I'll plan to be seeing you in person on the 7th. Houston in June. That is the place.
Houston in August you wouldn't like. Houston in June you'll like. Yeah.
I've been in both. Oh, yeah.
Alrighty, folks. Alrighty. Anything else from anyone? Alrighty. Have a good day. Thank you.
Thank you, Your Honor.